Thank you for staying with us on the program. Earlier this morning, I gave you a hint as to what our focus will be for this discussion on TMI this morning. It's about, obviously, for those who are just joining us now, the verdict of the Presidential Election Petition Tribunal from yesterday that ruled that President Muhammadu Buhari was eligible to run, to aspire to the highest office in the land, and of course to run as president of Nigeria. But on the other hand, the tribunal also rules that the PDP, and of course by extension former Vice President Atiku Abubakar, could not prove their points, all of the points that they raised. They want to help beat this conversation into shape this morning on the program. I am joined by Felix Osareme. He's a lecturer at the Department of International Studies and Diplomacy here at the University of Benin. Incidentally, I'm still expecting 2 more guests to be joining us this morning so we can expand the narrative on TMI. Thank you so much for coming on the program. I appreciate it.
Good morning, and thank you for having me on the program.
Great.
Good morning.
Obviously, you are still in Nigeria and you have been following the news. We all know what happened yesterday as to the verdicts of the tribunal, the Presidential Election Petition Tribunal, that is. This is not just a battle that started yesterday. Even before the election, issues had been raised about irregularities. Then, of course, opposition was also making noise about certain concerns that they had prior to the election. Incidentally, some of those issues also found their way post-election and then into the tribunal process itself. But yesterday, the plane landed, as it were, and we know where we are today.
Yeah. Well, the verdict of yesterday did not really come as a shock to some of us. In fact, it would have been a shocker if the verdict had gone the other way. We cannot remove the element of incumbency from the ruling that the Presidential Election Petition Tribunal gave yesterday in Abuja. And it was quite lengthy, started by 9:30 a.m. up till about 5:04 p.m. We were still giving out the verdict. And at the end, the 5-man panel led by Graba Mohammed came up with unanimous decision. And, you know, if you look at it from that angle, you want to be very logical, then you have to be clear as to the points that were raised and the decisions that were reached. The points that were raised concerns the petition filed by the presidential candidate of the People's Democratic Party in the person of Alhaji Atiku Abubakar. And the pleadings that he took to the petition tribunal were clear on some issues. Well, the issue of the candidacy of President Muhammadu Buhari, the issue of his qualification, his educational qualification, the issue of the transmission of results by INEC using the server, that's the electronic transmission of results.
Right.
Then they also raised the issue of the use of security agencies to intimidate, to harass, and to distort the outcome of the election. And these are very weighty issues. Some of these issues actually even carry criminal conviction if established. So if you take this template, therefore, you will find that the ruling yesterday tried to address each of these points. Of course, there's also the issue of inducement of voters using trader money, as the Vice President, Professor Yemi Osibanjo, was attached to the petition of the PDP. Well, there was also the other issue from the APC stating that Alhaji Atiku Abubakar was not qualified to even petition them. They also raised the claim that he was not even qualified to run for the office of the president because
being a non-Nigerian, as
they claimed, he was a non-Nigerian. So all these issues were brought to the fore. Then the issue of INEC, saying that Vice President Osibanjo should have been joined in the petition and that the PDP's claim should be disregarded. So all these issues were addressed point by point. Now, in legal terms, the petition that were before the tribunal is what the tribunal will address.
Sure.
So let us first of all look at the strict rule of interpretation here. And it will be that the tribunal will take what is before it and address it. And it will rely on facts, on evidence, on the testimony of witnesses. So it will not use conjectures it will work with what is before it. So you will now ask yourself, did the parties adduce evidence? Well, they brought a lot of documentary evidence, they brought some witnesses, and at the end, the Petition Tribunal ruled and declared that the claims of the People's Democratic Party lacked merit. And they gave some very interesting propositions. For example, they said that President Buhari is eminently qualified. You know, raising the issue will bring us to other discussions later.
Right.
But if we take it point by point, it is that the panel established certain positions, stating that for this, for example, they mentioned the issue of the server. Okay, let's take it one by one. We'll start from the educational qualification of the president. They are actually saying that the president, the affidavit that he deposited does not arise as an issue on which they can now bar him from continuing as president, because he is eminently qualified because of the scenario around this person. He has been in the military, he has served in different capacities. So all these things, in their own view, amount to qualification. But that's not what the Constitution says. Okay. So the Constitution is clear. You should have
minimum qualification.
Minimum qualification should have been secondary school leaving certificate.
Okay.
So the legal question would have been, do you have it or not? If you have it, present it.
But it will appear the law in most cases doesn't seem to do a two-way traffic kind of assessment of issues, a yes or no kind of scenario.
That is why the law is the law until it is changed. In fact, some people say the law is an ass. The law is the law until it is changed. So the law always is, to every rule, there's always an exception. Okay. The law will tell you that at least, you see, the law did not say it must be WAEC or JAM or NECO or IJMB. It said at least secondary school.
So the law is not necessarily recommending in specific ways. That's what
it does. But you see, when it comes to interpretation,
it becomes a problem.
Good. People can now, that's why there are rules of interpretation in law. You have this, the golden rule, the literal rule.
Incidentally, I think this is going to make a very beautiful and incisive conversation this morning on the program, because we're expecting the lawyer to also join us and lend his voice to this narrative. But let's take a quick break now. We're back shortly. Stay with us.
TMI, every opinion counts.
We appreciate you staying with us. I've been joined by two more guests. Let me begin from my far left now. Honorable Friday Ogiera, he Esquire, is a lawyer and a former member Edo State House of Assembly. Next to him, the man in heart, as I should call him right now, is Fred Uigwe. Fred is a politician and an economist. We appreciate you, gentlemen, for coming on the program.
Thank you for having me.
Great.
And good morning.
Just before you showed up, Felix here was talking about the interpretation of the law being an issue in many of the cases we have in Nigeria, particularly looking at the verdicts from yesterday, the Presidential Election Petition Tribunal verdicts. The law is clear on many issues, but most times I think sentiments and politics find their way into interpretation. I want you to lend your voice to that Friday as to how interpretation has become a problem, especially with regards to cases that are piled up in courts concerning electoral processes.
Well, as a lawyer, speculation is not an enjoyable pastime in our profession. But talking generally, there are canons of interpretation that judges will help themselves with, under any given situation or case. If I am to really discuss specifically the judgment of yesterday, in respect of the article PDP against Buhari APC electoral petition, I will say that it will be a little bit not too convenient, as it were, because I am not a party to the matter. I am not a lawyer in the matter. I have not read the judgment. I have to be very, certain in my position discussing it. But on a general ground, there is a jurisprudential school of thought which says the prophecy of what the court will say or do is the law. Now, the judges of the Court of Appeal, being the first court or the court with the original decision in respect of presidential election matters, has spoken. And as we speak, until that judgment is reversed, their position today represents the law. But again, talking as an ordinary Nigerian, and as with all modesty, an active person in the political arena, I will tell you that most election matters that goes to the tribunal are more political than legal.
Why so?
You can take that to the bank. The verdict that you find, all of the verdict that you have seen, dating back from when democracy took birth again, or bettered again since 1999 to date, if you look at it, you will see that most of them are a reflection of a political situation at any particular time. That is why you find that some cases that you want to rely on, because within our own legal practice, as a civil common law country, we ought to be relying on precedent. If a particular court has taken, the highest court in the land has taken a position on a matter, it serves as a precedent, what goes stare decisis. So that in subsequent cases, you can apply it to say, this is what is because that is representing the law. The court should also apply it in a given case that you are doing before it. But that has not been the case as we speak. But there are cases you will refer to in election matters, and they will tell you that election matters are sui generis. They are treated on this peculiar nature, not necessarily dependent on what has been decided before. They will also tell you that there are departures that are made to justify, some current political viewpoint, as it were. So that is why I said that the judgment that we have seen on election matters are more political than legal. And the judgment that we also find, particularly as related to the election matter, cannot be better than the political system that we operate and that we practice. I know as a Nigerian, I can speak on that, that whether, assuming it was even Atiku or any other party that won, not even Buhari, I know that election was not credible. That election did not meet with international best practices. That election was less than democratic. So
if we were to put that differently, given your view right now, what you're saying is it was not so much about who won as it was about the process.
About the process. About the process, because we have often said that we tend to take the line so much in the end of any of a matter.
Regardless of what leads to the end.
Regardless of what leads to the end. So if like I said before, that's my own opinion, and that's my own observation. And that also is supported by a lot of the report that came from international observers and what have you, which derided the process of that election that led to that declaration. But for the system, the status quo, it was sufficient that they came out with an outcome. There was a declaration of a winner. And that's so much for the snippet of what I had on that judgment when one of the justices was giving his own opinion about the judgment. He was narrating the procedure and step that will lead to the declaration of a winner, as it were, as stipulated in the Electoral Act. But talking again as a lawyer, I know that cases are won and lost based on the evidence before the court. I do know the kind of evidence that Atiku put before the tribunal, because like I said before, I was not a participant in the matter.
So you're not privy to all those facts?
So, like I mentioned from the onset, that speculation is something that a lawyer do not find fanciful. So I cannot rely on maybe media report of what happened, what transpired, because even media report could be a reflection of who is doing the report. So I will not rely on that to say, oh, the verdict ought to have gone otherwise. But what I'm saying is that going by what happened in that election, it ought not to stand the test of time.
Okay, I'm going to.
That election was like I said, less than deserving.
Well, we're going to look at a bit of more, if you will, constitution-specific issues in the bit. But let me come to Fred now. It will appear what happened yesterday is what a man like President Barack Obama would have said it's been a long time coming. A lot of people believe what happened yesterday was just, as it were, the climax of a long drawn-out event, going back to the, for want of better words, dysfunction in our political space.
Some time ago, I was here, and I remember you shutting me down when I made a specific statement.
Maybe we were stepping out of bounds on the program at that time.
No, yeah, I would not say that. I think you were being careful, being a representative of, an organization that is guided by laws and regulations, external laws and regulations. When I said that we were sure of what the verdict was going to be, and that the verdict was going to be in favor of APC, going by the precedent of judgments that we have witnessed in this country over time, that they were always, or they always seem to be in favor of the incumbent or the party controlling the national government at the time. So that was my presupposition for saying that this particular case was also going to go that way. That said, we listened to what one of the attorneys there described as the longest judgments ever given in the Nigerian court, spanning over 8 hours, almost 9 hours.
That's landmark.
And the most comprehensive by every standard. I very much understand the care that our honorable legal professional here, Honorable Friday Ogeraki, advances, being wanting to be careful. But we were privy, or at least we listened to some of the arguments that informed the decisions as the presiding judge read. And those are the arguments that we must revisit to be able to be able to determine if they were sufficiently rational, sufficiently logical to have arrived at those decisions. And I will mention some specifics, like the issue of the certificate. But before I go there, let me just say this. The petition was based primarily on 5 issues. Any failure on one of those issues could have nullified the elections. So it was important to have all 5 petitions, or the 5 elements of the petition dismissed or nullified. So I'm not going to talk about all of them because I don't believe I can remember all of them, but I will talk specifically on a few of them. Let's take the certificate issue, which borders on qualification.
Pre-election matter.
Yes. Not, yes, pre-election. Yes. The process starts from there. But at any time, it is determined that any of the candidates I've been an aspirant before. Any of the candidate has tendered certificates or qualifications that didn't meet the requirement, the person stands to be disqualified.
At any point?
At any point. Whether before, during, or after, the person stands to be disqualified. So we are talking about the certificate issue. The law, the 1999 Constitution as amended, that's legal professionals would always like to add, called for a secondary school leaving certificate.
As minimum.
Certificate, or its equivalent as minimum. You could come up with a degree, but like they say, you cannot build something on nothing. If you do not have that certificate, your degree does not count. So you must have that as a base on which to add other qualifications. So if that is the requirement, from the judgment yesterday, we were told that what was important is that the person had attended secondary school up to the final year level. That is not what it calls for. It specifically calls for a certificate. That is to say that the person has sat for an existing examination and has passed it. There is what many of the younger generations will probably not be familiar with, that we used to call G4. G4 means government class 4. Anybody who has gone through secondary school up to Form 5 or up to the final year, which is now JSS3.
SS3.
SS3, I'm sorry, which is now SS3, and did not pass out, did not have a certificate, is considered to have had G4. Maybe in this case that would be something like G5. That's to say the person passed from 4 to 5, but failed to graduate because the person did not sit for an exam and get a certificate. So there are two different things. And everybody knows, there's nobody who attended a secondary school in Nigeria who doesn't know that the school is obligated to give you a testimonial for attending, that's full completion of the program, as different from the certificate which you receive from the external body. Okay? So before we had the West African School Certificate, there was the Cambridge examination body, from which this certificate by the president was supposed to have emanated, which was not produced, could not be traced, and could have easily been redressed if there was no lacuna by the president, being the only person who could have applied for a certified copy of that particular certificate from the examination body. That wasn't done. So on that score, in my mind, it failed all logic of qualification and all rationale of qualification. So it failed in that. In the case of improprieties by the agents of the candidates, that the judgment also diverged from the responsibilities of the candidates. He said that because, the judgment said that, because the candidate was not there when those infractions were committed, then he could not be held liable. That was just simply laughable, because in the law, in the agency law, an agent is deemed to be a full and complete representation of the principal, to the extent that he's empowered to represent that principal. So whether the principal is there or not, that agent, that principal must take responsibility. You are here now. You are representing ITV. All you do here, the infractions for which ITV could be sanctioned may not be infractions not seen anywhere, will be the infractions that you being a representative and agent of ITV, commits here in this broadcast, and for which ITV, not you, will be sanctioned. That's agency relationship. So you cannot divorce an agent's responsibility or a principal's responsibility from that of an agent's responsibility. It is responsibility. How you hold him accountable, it's a different thing. If you want to say you are holding him accountable to certain limits, then we must determine to what limits. So those are two aspects, for example. So the improprieties of the elections that would have necessitated either the nullification of the election or a new election should have been considered. When we think about Kenya and that the judicial system there had the guts, had the strength, let me put it that way, had the strength to nullify a presidential election and call for a new one, we will say yes. That is an exercise to an extent of independence of the powers of the judiciary. What we are saying, to broach something that you said here, if the process was leading on to it. So we cannot now say that the removal of Honore wasn't designed to all play into what we saw yesterday.
Okay, while we find a way to wrap our heads around that insinuation, let me come back to Felix now. Both of them, these two gentlemen here, have talked extensively about the process itself, the outcome, and a handful of the implications. But let's look at the issue of certificates, the scandal in particular, right? It became controversial. And some persons will argue that we needed to deal with that conversation for that long, putting in so much of time and energy because we have a system that doesn't really deliver optimally. That in a saner climb, which also, by the way, makes it difficult to determine how sane a climb is, you would have to put in all those resources trying to figure out whether a candidate at any point in time has a particular qualification they claim they have or not. What does that teach us about this whole process so far? Sincerely,
it takes the wind out of the sail of the ruling party and the president himself. You see, this problem did not start today. 2003, 2007, 2011, up to 2015, when Buhari won the election, he has always been a contestant. So if you take it in the historical perspective, you will simply ask yourself, what kind of a country do we really operate, where we have selective amnesia? We pretend to let things go when it is convenient for us. And when it's not convenient, we raise up those arguments. Before the co-discussants in this program came in, I just mentioned something. I said, look, it is clear what the Constitution says about the qualification, saying that, because the ruling said is eminently qualified, sufficiently qualified. That is not, that is grammar. Reality, you were saying that the law did not specifically say. I said, yeah, the law said school certificate, second school leaving certificate, or it's equivalent. That's why I said the law always gives, there to every room, there's an exception. They will say this or its equivalent. They never said attendance in school is an equivalent to a certificate.
Even if you spent half of your lifetime attending.
You see, that means the university system, the secondary school, primary school, anybody can just walk in and walk out and you are, okay, you are educated, you are qualified. That's what that ruling is now saying for us. Then it means we cannot charge fees anymore. Even if we charge fees, anybody can just drive a trailer into the school compound, drive it out of the school compound. It's already a graduate. So why am I going to lecture as a lecturer? Why should I even ask students to sit in my lecture room, examine them? Why do we subject them to that test of competence? If we say all the yes, Buhari spent in the army is not sufficient to nullify the fact that he doesn't have the school certificate. If he has one, he should bring it up. You see, this is just the rhetoric we have been talking about. Nigeria is the theater of the absurd.
But again, I love the fact that you made reference to the number of years. I mean, all of the election circles where Muhammadu Buhari, as a candidate back in the days, had contested. Featured. And then you're asking yourself, what does it say about institutional competence? That's one. That's the point. And second, there were people who also had contested with him at every point in time. Why did they not raise all of these issues long before now?
Because each time he lost. And you see, as our Honorable Ogirahi has just said, you don't need to speculate some of these matters. Okay. These are issues that are as clear as day and night. And these are issues that the international community sometimes sit back and wonder, say, what are those people doing there? What kind of human beings are there? Obama said it when he was president that Africa does not need strong men. What we need are strong institutions. If institutions are actually functioning very well, Buhari would never have been a candidate. That is the reality.
Given the reality we have in front of us.
He would never have been a candidate. And this is what our discussion has just also established, on that the system, if you look at the logic of the decision, you are simply asking, does this man have the qualification or not? Whether you go and swear an affidavit to cover up your lapse, or you now say that you have an attestation, there are two things you have to present. It is either you present a certificate or you present an attestation from that organization saying that there is a certified true copy. Because at times they will say, okay, this is your certificate. They will now say, no, bring it back. Let us actually say that we issued this one. We have not seen such. So the reality is that, in fact, I am in the educational sector, and I want to say that if I go out tomorrow and that says something, why are you not in school? Why are you not facing your studies? I want to be a bit circumspect now. Because it has just gone out yesterday that you can say you have spent some time, you are now okay.
So if I spent 3 years in a 4-year program without necessarily graduating, I'm okay.
Even if you spent 5 years in a 4-year program, but you didn't come up with a certificate, you are found to have been eminently, sufficiently.
That sounds scary. But let's see how we can address some of those, because there are also underlying issues we must look at, gentlemen. Let me come back to you on a Friday. The Justice Mohammed Garba-led tribunal has said that the Constitution, I mean, I'm paraphrasing now, does not envisage electronic electoral process. For example, the issue of the card reader. And then that the APC, I mean, the PDP in particular, could not establish that there was a server, that INEC had a server in place. That's one. Then two, that results were transmitted electronically. These are all issues of the Electoral Act, which also was a big conversation before the election. And now we're back to the beginning of this whole exercise again.
Thank you for bringing this issue up. First, I will say that it will seem that as a people, we dwell so much on irresponsibility and total respect. I will take you back to 2015, when the Jega-led INEC introduced card readers. After they did that, there was huge enthusiasm that at least we have found a panacea to our electoral problem. We now have a sure way of verifying and authenticating actual votes and making them count. What was most shocking and ridiculous, and perhaps even scandalous, was that the same INEC that used the taxpayers' money to procure those devices were the same people who hired lawyers with the same taxpayers' money to delegitimize the card reader in the court, right from the tribunal to the Supreme Court. And at the end of the day, the Supreme Court ruled that card reader was unknown to our electoral law. So that time I did an article that was published in major national dailies, particularly this day newspaper, where I said, you don't blame the judges. Those who first betrayed the card reader was indeed the INEC that introduced it, by virtue of what they did. They made so much song of it. Today, when they first filed this petition, the article petition, and there was so heavy weather made about Saba, I laughed. Because I said, why would these people dwell on futilities? Because as they are not turned out to be, I know I can predict that accurately, that the Supreme Court is going to uphold that position. It was a necessary futility. When you already know that the so-called Saba, as it were, is not part of the requirement of what is required in the process of conducting the election. I wonder why they dwell so much on it, make so much noise about it, protest part, and all of that. So I'm not entirely disappointed at all that the Court of Appeal said no, you couldn't prove the existence of it. It is not even part of our law. Like I said, I listened to a snippet of that judge, one of the concurring decisions. When the Honorable Justice went all out to detail the process from the voting to the collation to the entry of the figures in the specified form. He said that is what our law expects, and that as far as it's concerned, the INEC has complied with that procedure. So that they were looking at the law the way it is. So for me, I think if you want to look at what happened yesterday, PDP and Atiku, they actually lost that case a long time ago. Because if you look at the series of actions that preceded it, when of course attempts were made by the National Assembly to make reforms of our electoral act to now incorporate this electronic system, as it were, into the body of electoral laws. 4 times that bill was presented to this particular president, who knew that he was going to be a participant in the election. 4 times he declined. For those 4 occasions, I expected as a vibrant opposition party that of course effort would have been made to ensure that the president, hearkens to the voice of the people, because the National Assembly, if you want to look at it from whatever angle, is a representation of the Nigerian people. And if they went out and they took their time, effort, and what have you, to make reforms of our electoral system, to incorporate these electronic matters, because we all knew what happened in 2015. And President Buhari, because he was going to contest the election, knowing that it would be perhaps difficult for him or his party or the other person to manipulate the process if it were electronically recorded, declined access to it. That is why I said, as a matter of fact, the PDP and Atiku, as it were, they prepared to fail. But because no sufficient was made.
Just, you opened your own aspect of this conversation this morning when you talked about the fact that in your profession, speculation is not a pleasant pastime.
Yes.
You just talked about the fact that the president had withheld assent to the...
That's a part.
Yes, exactly, to the electoral act. The president made it clear at that time.
Yes.
In fact, the presidency made it very clear in an official statement that the reason the president would not give his assent at that time was because it was too close to the election. But maybe we can have that conversation another day. Just maybe.
But that was a lame duck excuse. That was a lame duck excuse. Because see, what are we dealing with here today? What we are dealing with here today is that if we don't have proper elections, our democracy is endangered. In fact, if we don't even have proper election, we cannot even claim to be practicing democracy. So that is the issue. And we expected for a Buhari that went to the tribunal on the 3 occasions that he lost election, from the first court to the Supreme Court, from the first court to the Supreme Court and lost, that he himself would have admitted that something fundamental was wrong with the electoral system. And it would have been from the onset, from day one, a matter of priority for him. But when he had the opportunity, he shied away from it. We once had a president, Shehu
Umar Musa Yar'Adua, of blessed memory, who after he even won at the Supreme Court, came forth courageously to admit that my election was fraught with irregularities. And I joined voice with him. I joined my voice with him, even speaking from the grave, that the electoral system of this country is in fact is a comedy of a sort.
But some persons also said at that point.
It's a comedy of a sort. It's a huge joke.
Some persons also said at that point, sir, that the president should have done something a bit more honorable, which was to resign. You didn't share that sentiment.
Because you see,
because if the elections were flawed, it puts a question mark on the legitimacy of your government, doesn't it?
It was not necessary for him to resign, but he did what was patriotic and nationalistic. When he now went out to say, when he now went out to convoke a panel to look into areas where we can make reforms, so that we can have credible election that we can be proud of. I am not proud of this kind of electoral system. Like I said before, even if Atiku had won, he had been declared winner of the 2019 election, I would still have come here to tell you that the election was not credible.
Okay.
So it is not about personalities. It's about process. It's about the process.
Best practice.
So now the issue of electoral voting, as it were, I think this again is a wake-up call for all Nigerians. It should be so. Even the opposition party, I don't expect them to, after doing all this, go the whole gamut. From now, they have given signal that they go to the Supreme Court, that they should go to sleep. This is the time to commence serious agitation that will ensure that electronic voting and counting of votes, as it were, become part of our electoral system. But because we sued the system that be, he sued them. He sued them. In fact, they take delight in it. And I say again that the reason why Buhari declined assent to those bills was because he knew we were going to stand for election, and that if the election were credible, the result would have been otherwise. So it is a wake-up call for all of us, all stakeholders. I don't expect anybody to go to sleep now. Even whatever become the outcome of this petition at the Supreme Court of the appeal they were eventually filed, I think it is something that we must take seriously. We must go to bed with it and wake up with it. Otherwise, we don't have anything close to democracy.
All right, before we go to bed, let's see the challenge that former Vice President Atiku Abubakar and the PDP had to deal with. The burden of proof, as they call it in law, Fred. It will appear at the points, the way the events turned out came as a rude shock, to say the least, to the PDP and, of course, its candidates, Atiku Abubakar. It was quite a tall order, I mean, proving many of those points that they had raised in their petition, right?
Very true. Before I go there, let me just visit what the lecturer told us about that certificate thing and all of that.
Okay.
That by the judgment yesterday, the requirement for qualification has been diluted. And so other aspirants or candidates can now come forward to begin to apply to contest positions for which they lack certificates, just because they are qualified by attendance only. That is what that judgment did, which is very dangerous to the process and to our democracy. And to come back to this matter of transmission of results.
Yeah.
The very purpose of transmitting results is to secure the authenticity, the legitimacy, the accuracy, that's the word, the accuracy of what transpired at the polling booths. That is it. Whether you rode in camels to transport the results, or you rode in cars or bicycles to transport the results, or you put the result in your breast pocket or your back pocket, which were like the arguments made yesterday for us, that how you carried the accuracy of the result to where it was announced becomes the reason for nullifying the results. It's laughable. It's ridiculous. Because we keep saying the first things you hear about all kinds of democracy, it's freedom to exercise one's franchise. Free, fair, and credible. Credible means what transpired properly, on due process, and then announced as transpired. So, the elections took place. How did the election get to where it was announced? So that becomes the issue. The card reader device or technology or addition or improvement was a welcome development when Jega introduced it. Okay. One thing it did for us was to enhance the accreditation. And number one, actually, to authenticate the voter. Okay. Voters haven't been authenticated and accredited to take part in the exercise. Haven't done that to make it more credible. See, the results must be deposed to on sheets from EC, 8A and all of that, on paper, and signed by the agents. Remember I referred to the agents? Signed by the agents of the principal. Principal being the party and
its candidates.
The candidate. So they must have signed, and that authenticates it. And that matter, what is authenticated is taken to the organizing body to announce results. What we ought to have been contesting is whether what was transmitted or what was purportedly transmitted was different from what happened, and not how it was transmitted. Okay? And then we have to remember that prior to the elections, INEC's employees, INEC public relations officers, employees, came out on several national televisions.
The same thing they did with the card reader.
And told us all that this is going to be their process, including transmission, electronic transmission of the results, as an improvement on what happened on that Jega's time.
And that was also a welcome development.
It was a welcome development, and we were all very happy, and we all welcomed that, that was going to be. And I'll say here, and I think I said it here before, that during the past election, it was on my suggestion to APC that they have an independent command center, collation command center, where they too could have results as on real time, so that INEC will not have the opportunity to announce a different result. And they took that advice. But the very promise, or the very promise of electronic transmission of results via the card reader made that unnecessary for PDP, because now INEC was taking it upon themselves to electronically transmit. And then INEC also had a budget of some 32 or was it 38 billion naira purportedly in part of their 249 or 200 and something billion naira budget
for the process.
For improvement.
I think this is getting a bit more drawn out, and it's getting
for improvement of the technology.
As we wrap it up on this discussion, I want to come to Felix. What are the takeaways for us? What are we learning going forward on account of trying to
please, can I quickly add this?
Yes.
If Buhari were to remain in office for 20 terms, if that were allowable, I can say right now that Buhari will never assent to an improvement in the election.
Exactly. As it were now, give or take, that is only hypothetical, because the Constitution does not allow any Nigerian.
Because 4 times he had the opportunity to do that.
Let's look at what we're taking away. Let's look at what we're taking away from all of these processes, given what all you 3 gentlemen have been talking about on the program in 1 minute.
It's a sad day for Nigeria as a country in 2019 to be taking bold steps into medieval existence. That's where we are going to. We are not going forward at all. And when we sum up all these things, from the judiciary, from the legislative arm of the government, to the one that pretend
that's the executive.
We'll come to one conclusion here, that we have not decided to progress. In fact, we are wallowing in irresponsibility. And with the kind of pronouncements that came out yesterday, the celebration that is going on in government and in the ruling party right now, we are setting the stage for further decimation of progress in Nigeria as a country. I'm not saying development in proper terms. We must be blunt, we must be frank. We should not run away from that. This is not hypothetical. The rule yesterday has now made it difficult for me to go to my class and tell students that they have to be studious, they have to be hardworking, they have to be...
Please, so, you have to continue to tell your students what you have been telling them, that they have to graduate.
It's more difficult for me. It's already a difficult task I'm facing.
Yes.
It's going to be more difficult because they are going to ask me to what end. And when they process a system does not encourage you to be up and doing, does not encourage you to be hardworking, or does not encourage you to be diligent. Even if I'm saying it, and I'm seeing that the alternate is what is happening out there.
Okay,
because
that's the much you can allow these brilliant gentlemen talk about on the show, because this is a conversation that can go all the way, even into dinner time today, but time will fail us to do all of that. I want to thank very specially 3 of my guests on the program. Felix Osarime is a lecturer, Department of International Studies and Diplomacy. Next to him is Fred Uigwe. Fred is a politician and an economist. Then, of course, we have Honorable Friday Ogerahi, who doubles as a legal practitioner and a politician as well. Gentlemen, thank you for coming. We appreciate your time on the program. And that's what we're putting an end to this conversation this morning. I'm back to tie it up very shortly. Do stay with me.